Back Home Media.
Welcome to the Elkhart Tapes, the podcast where we delve into mysterious and unsettling events that shaped this small town. I'm your host, Derek, and today we're talking about late January and early February of 1978, the quiet town of Elkhart, Kansas. It's a story of three people whose lives intersected in unexpected ways. Mary Edna Haslett, an 83-year-old widow who lived alone, Jim Hildreth, a 62-year-old man known around town, and Charles E. Henderson, a newcomer to Elkhart with a past that would soon come under scrutiny. What started as a simple evening of drinking and socializing would soon take a dark and tragic turn. Segment 1, the calm before the storm. Charles Henderson arrived in Elkhart just days before the incident. He found a place to stay at Jim Hildreth's home. The two men quickly struck up a rapport, and as often happens in a small town, they visited neighbors together. One of those was Mary Edna Haslett. On January 31st, 1978, Mary Edna welcomed both Henderson and Hildreth into her home. Together they drank whiskey, watched TV, and shared this simple camaraderie of winter evening. But as the hours progressed, their supply of whiskey ran dry. Around 8 p.m., Mary Edna drove to a local liquor store to restock. When she returned, Henderson asked her for a ride to Sublette, a nearby town, but Mary Edna refused, perhaps because of the worsening weather or the late hour. Shortly after Mary Edna returned with more whiskey, Jim Hildreth left. He said he was going to a neighbor's house to retrieve a dog chain. That left Mary Edna alone with Charles Henderson. At around 9:30 p.m., the police were called to the Jim Dandy grocery store just a block and a half away because Hildreth was causing a disturbance. An officer picked him up and took him home. A couple hours later, Hildreth reported a break-in at his house, but officers found no evidence to support the claim. What really happened at Mary Edna's house after Jim Hildreth left? And why was Hildreth causing disturbances around town? It was February 1st, 1978, a bitter cold morning. Jim Hildreth went to the Jim Dandy store again. This time, his behavior was even more concerning. He purchased a bottle of aftershave lotion and drank it right there at the store. After that, Hildreth tried calling Mary but got no answer. Worried, he asked the store's proprietor to join him in checking on her. They arrived at her home only to discover a tragic scene. Inside the house, Mary Edna Haslett was sitting upright in her rocking chair, lifeless. There were no obvious signs of violence, but something was off. Police and the coroner arrived swiftly, and as they began examining the scene, an officer noticed footprints in the snow behind the house. The heel of the shoe left a peculiar asterisk-shaped mark. However, the matching footwear was nowhere to be found. The same morning, a white pickup truck parked just 2 blocks from Mary Edna's house was reported stolen. Was this connected to her death? With Mary Edna gone and odd footprints, plus a missing vehicle in the picture, Elkhart braced itself for shocking answers. No one knows the exact time Henderson left Mary Edna's house, but we do know that between 8 and 9 p.m. on January 31st, he was spotted in Elkhart purchasing gasoline, driving a white pickup truck that was later reported stolen. By the next morning, the stolen truck was found abandoned along Highway 270, east of Hugoton. The CB radio inside of it had been removed. Henderson later sold a CB radio in Liberal, Kansas, matching the truck's serial number. But Henderson did not stop there. At the Cimarron River Bridge south of Ulysses, he forcibly took another car, leaving the white truck behind. Days later, authorities apprehended him in Kearney County driving this stolen vehicle. By this point, Henderson was the center of a growing investigation. His flight across multiple counties suggested desperation and potential guilt. Henderson's run from the law ended north of Ulysses. Investigators wasted no time piecing together the events linking Henderson, the stolen truck, the missing CB radio, and most importantly, the suspicious death of Mary Edna Haslett. But questions remain. Why had he left Mary Edna's house at all? And what, if anything, did he have to do with her death? Segment 2, the autopsy findings. The cause of death was asphyxia. The states theorized that Charles Henderson suffocated Mary Edna with a pillow. Investigators found a pillow with a small blood stain and salival marks hidden beneath the folded clothing in her bedroom. If this pillow was indeed used as a murder weapon, it pointed directly at foul play. 3 physicians testified. First, Dr. Perito, Mary Edna's personal doctor. He reviewed her medical history, fractures, EKGs, revealing a past heart attack, and concluded that she did not die from a heart attack at this time. He based this on the discoloration he observed on her neck upwards, arguing that if Mary Edna had died of natural cardiac causes, the molting would be more generalized. With Perito's testimony supporting homicide by asphyxiation, the state bolstered its claim that Henderson deliberately suffocated Mary Edna. But more medical experts were on deck, one whose testimony would either confirm or challenge Dr. Perito's conclusions. Dr. Boyle, a pathologist from Wichita, was called by the district coroner to perform an autopsy on Mary Edna Haslett. He described dark discoloration from her collarbone to her scalp and noted several superficial abrasions on her chin, nose, and eyebrow, injuries consistent with the application of fabric under pressure. He found no sign of strangulation, nor did he find foreign fibers in her nostrils or mouth. Yet based on fluid accumulation in the lungs, pinpoint hemorrhages, and heavy blood pooling in the brain, Dr. Boyle concluded that asphyxiation was probably caused by suffocation. Dr. Boyle dismissed the idea of a fatal heart attack, citing no major arterial blockages or significant heart muscle damage. This pointed away from natural causes and toward a deliberate act. With Mr. Boyle's testimony, prosecutors had a powerful piece of evidence. Mary Edna's death, they argued, was no accident or act of fate. Dr. Boyle, however, could not determine the exact time of death. That left the door open to speculation about when Mary Edna was killed and by whom. Dr. Elkhart was board certified in anatomic, clinical, and forensic pathology, making him an authority whose testimony would balance or even contradict Dr. Boyle's. His analysis drew on Dr. Boyle's autopsy report, Mary Edna's medical records, and literature on asphyxial deaths and circumstantial evidence around the case. Dr. Elkhart pointed out that death by suffocation in a conscious adult is uncommon without signs of struggle. He argued that Mary Edna's injuries could equally align with a sudden heart event, especially an electrical malfunction of the heart, which wouldn't necessarily leave arterial blockages or muscle damages. In his view, both suffocation and heart failure were probable causes of Mary Edna's asphyxiation. Dr. Elkhart's testimony introduced critical elements of reasonable doubt. If Mary Edna might have died from a cardiac issue, was Henderson truly to blame? All the evidence here is circumstantial, yet Kansas law firmly establishes that even the gravest offenses can be proven by circumstantial evidence alone. So the question is whether a rational trier of fact could find guilt beyond a reasonable doubt, given the footprints, the stolen truck, the suspicious pillow, and Henderson's flight from the scene. Per Jackson v. Virginia, appellate courts don't weigh evidence themselves. They ask if any competent evidence supports each element of the crime. If so, the conviction stands. For Henderson, that means if the jury believed he caused Mary Edna's death beyond a reasonable doubt, the conviction is legally sound, even absent direct eyewitness testimony. Given Henderson's presence at Mary Edna's home, the stolen truck, his departure around the critical time frame, and the pillow indicating possible suffocation, the state argues these circumstances pointed unmistakably to homicide. In homicide cases, corpus delicti requires two facts. One, a person was killed, and two, another person caused that death. No one doubts that Mary Edna died, but did she die from a criminal act or a natural cause? Henderson insists the state's own medical experts, Dr. Perito and Dr. Boyle, didn't conclusively rule out a fatal heart event. If her death could be explained naturally, then the first element of homicide, that she was killed by someone, might not be met. If the cause of death remains as consistent with natural causes as with foul play, the defense contends the state hasn't proven corpus delicti beyond a reasonable doubt. Still, the state points to the suspicious pillow and the medical findings suggesting suffocation. According to Dr. Boyle, these injuries and internal signs strongly favored homicide. In the State versus Doyle, the court observed, quote, where the circumstances are as consistent with the absence as well as the presence of a crime, the corpus delicti has not been proved, end quote. This suggests that if the facts could equally point to a non-criminal scenario like accident or suicide, then the prosecution hasn't met its burden. On the other hand, Doyle also affirms circumstantial evidence is acceptable if it's the best available, provided it excludes every reasonable hypothesis of innocence. If there's a reasonable alternative explanation, the defense can argue the jury shouldn't convict. So how does this standard apply to Mary Edna's death? If Dr. Elkhart's testimony left room for natural causes, can the state truly claim it had excluded that possibility beyond a reasonable doubt? Segment 3, the evolution of legal standards. Later Kansas cases like State versus Johnson explicitly reject the requirement that circumstantial evidence must exclude any reasonable hypothesis except guilt. The U.S. Supreme Court, Jackson versus Virginia, Holland versus the United States, otherwise ruled the prosecution don't have to negate every possible innocent explanation. So while Doyle once implied suicide or natural causes must be definitively ruled out, later decisions emphasize the jury's role in determining whether the evidence is sufficiently compelling for a conviction. In cases like State versus Sagabill and State versus Sparks, courts found Doyle inapplicable when there was more direct evidence, such as witnesses seeing the crime occur. By contrast, Doyle involved a victim found dead under an ambiguous circumstance with no one else around. For Henderson, the critical point is whether Mary Edna's death truly mirrors Doyle, an equal possibility of suicide or accident, or whether the pillow's bloodstains, footprints, and Henderson's flight push the case beyond a reasonable doubt. As we'll see, the court ultimately balances these various precedents, deciding if the state's evidence made homicide the more convincing explanation than any other alternative scenario. Yes, Mary Edna could have died from heart failure, yet Dr. Perito and Dr. Boyle testified that they believed it was suffocation, not a cardiac event. Dr. Boyle identifies injuries consistent with something, perhaps a pillow, being pressed against her face. Together, their testimonies were enough for the jury to see a criminal act as the most probable cause of death. Even though Dr. Elkhart disagreed, appellate courts don't second-guess how the jury weighs on expert credibility. Evidence placed Henderson at Mary Edna's home shortly before her death. He left abruptly, stole a truck, and fled. His actions suggested the consciousness of guilt, at least in the state's eyes. Under Jackson versus Virginia, these facts gave a rational jury enough to convict Henderson. Thus, the court found no issue with establishing the corpus delicti or linking Henderson to the crime, at least insofar as meeting the legal sufficient standard. On appeal, the question wasn't whether the judges personally believed Henderson was guilty, but whether enough evidence existed for the jury's verdict. The answer was yes. Segment 4, Bill of Particulars. The state's Bill of Particulars said Mary Edna was killed between 8 and 9:40 p.m. on January 31st. But at trial, the state never nailed down an exact time of death, which Henderson claimed forced him to craft an alibi for all the hours until her body was found the next morning. The law only requires the state prove essential elements of the crime. Failing to prove an exact time isn't automatically fatal, especially if the defendants can't show how this ambiguity specifically prejudices his defense. Henderson struggled to provide a robust alibi even for the 8 to 9:40 window. One witness placed him buying gas around that time in a white pickup. As for pointing the finger at Jim Hildreth, the court noted Hildreth was around town the entire evening, making it difficult to shift suspicion onto him. The appellate court saw no actual prejudice from the state's failure to pinpoint the precise moment of death, holding that Henderson received sufficient notice to mount whatever alibi he could. Since he couldn't even cover the narrow window, the broader timeline made no real difference. Henderson alleges that the special prosecutors erred him by 1, calling attention to Henderson's failure to testify, 2, suggesting that a conviction could be reversed on appeal while an acquittal was final, and 3, stating the prosecutor's personal belief that Henderson was guilty. Defense counsel promptly objected to the first and third statements. The trial court overruled those objections, and no one specific objection was made about the appeal argument. Under Griffin versus California and Kansas statute KSA 60-439, it's unconstitutional to comment on a defendant's silence. But the real question is whether the prosecutor's remarks naturally led the jury to focus on Henderson's choice not to testify. Some courts apply a harmless error test. Was the comment so minor the jury likely would have convicted him anyway? But if the error isn't harmless beyond a reasonable doubt, reversal may be warranted. The special prosecutor mentioned that in the ancient times, suspects were tortured until they confessed. Then he contrasted that with our modern system, highlighting the right not to testify as the high standard of proof. He pointed out that if the jury returned a not guilty verdict, it would be final. He pointed out that if the jury returned a, quote, not guilty verdict, it would be final. Henderson would be, quote, even more innocent, quote, than the jury members themselves. But if they convicted and erred, a higher court could reverse it. Such remarks risk trivializing a connection by implying the jury's errors aren't permanent. It also might subtly hint that Henderson's silence is suspicious. contrasting modern no-torture trials with the medieval notion of forcing a confession. Defense counsel argued this improperly commented on Henderson's failure to testify. The trial court disagreed, and the prosecutor's remarks stood uncorrected. The prosecutor had also stated that he personally wouldn't prosecute someone if he thought they were innocent. This injects the prosecutor's own credibility into the verdict, something professional guidelines frown upon. According to Knowles versus United States, an error exists if the statement was manifestly intended or was of such character that the jury would naturally and necessarily take it to be a comment on the accused's failure to testify. In Doty versus United States, the 10th Circuit found this error serious enough to warrant reversal without a contemporaneous objection. Applying this to Henderson's case, the appellate court decided the prosecutor's remarks, framed as a historic reflection, could still be interpreted as referencing Henderson's silence, especially since the state's evidence was totally circumstantial and not overwhelming. If the evidence is overwhelming, maybe these remarks would have been harmless beyond a reasonable doubt. But here, with an arguable suffocation theory and no direct witnesses, the comments could have tipped the scale. Hence, the court found these statements not harmless. Coupled with the idea that a wrongful conviction could be reversed on appeal, the total effect compromised Henderson's right to a fair trial. The argument that an erroneous conviction can be reversed, but an erroneous acquittal cannot, improperly diverts the jury from its duty. Courts in multiple states have held this as prejudicial, as it downplays the finality and gravity of a conviction at a trial. The ABA standard for prosecution function and Kansas' own code of professional responsibility forbid a lawyer from asserting personal opinions on guilt or innocence. In State versus McLean, the Kansas Supreme Court echoed this stance. However, courts also consider whether such statements create prejudice. Minor or vague comments may be brushed aside, especially if a judge instructs a jury to ignore them. In the Henderson trial, the prosecution went beyond a mild remark. He, quote, wouldn't dream of prosecuting someone he thought was innocent, implying personal certainty of Henderson's guilt. Defense counsel's objection was immediately overruled. Given the state's case was largely circumstantial, the court feared the jury could be swayed by the prosecution's personal credibility, especially in a small town setting where the prosecutor's standing was well known. Ultimately, the appellate court deemed these combined errors, comments on silence, suggestions with appeals, personal professions of guilt, sufficiently prejudicial in a case lacking evidence. Thus, they reversed Henderson's conviction and ordered a new trial. A witness who sold gasoline to Henderson was present on the first day of the trial, but suddenly fell ill. Hospitalized, he couldn't return, yet his primary hearing testimony placed Henderson at the gas station between 8 and 9 p.m., aligning with the state's theory. Defense counsel wanted a mistrial, hoping the witness might testify to an earlier time if he appeared in person. The court instead allowed the state to read the witness's preliminary hearing transcript. Under Kansas law, if a witness is genuinely unavailable despite reasonable diligence, prior testimony where the defense had cross-examined him can be admitted. Cases like State versus Stewart and State versus Alderdice support this view. The appellate court found no error here, concluding the defense wasn't unfairly prejudiced since it had already cross-examined the witness under oath. Henderson also compiled that the trial judge didn't keep confidential his ex parte motion to hire a pathologist at the public expense. However, the appellate court found no harm. The state already had its own experts and did not acquire new ones in response. The court saw no prejudice because Henderson did not have disclosed strategy, and the state gained no advantage from learning of the defense's expert. Thus, neither the missing witness issue nor the pathologist's confidentiality warranted reversal. But as we've learned, and errors participating in closing arguments did. After weighing all of the issues, witnesses' availability, evidence timelines, expert testimonies, and prosecutorial conduct, the appellate court arrived at a definitive conclusion. Quote, for the reasons stated above, the judgment is reversed and the case is remanded with directions to grant a new trial, end quote. This means Charles Henderson's conviction is no longer valid and he's entitled to a fresh trial, free from errors and improprieties highlighted by the court's decision. Not everyone on the bench shared the exact same view. Justice Frome chose not to participate in the decision, and Justice McFarland, while concurring with the overall reversal, dissented from the majority's finding that the prosecutor's historical allusions amounted to a comment on Henderson's failure to testify. Quote, I see nothing in the comments which can be reasonably construed as referring to this particular defendant's failure to testify in this particular case, end quote. Still, the court's majority opinion carried the day. So what does this mean? One, prosecutorial conduct. The decision underscores the need for restraint in a closing argument. 2, circumstantial evidence. It reminds us that while circumstantial proof can be sufficient, it isn't always bulletproof, especially if procedural errors occur. And 3, fairness and safeguards. Ultimately, the justice system leans towards ensuring a fair trial, even if it means a retrial when error creeps in. With a new trial ordered, Charles Henderson's fate remained undecided. Which brings us to the end of this episode of the Elkhart Tapes. Even in a small Kansas town, the pursuit of justice can be complex and nuanced. This case stands a reminder that fair play, judicial standards, and the thorough examination of evidence matters deeply in our legal process. Thank you for joining us for this detailed expedition into the real-life trial and appellate journey of Charles Henderson. I wasn't able to find anywhere online how the second trial turned out. If any locals know, please give me a message, and I'll relay that information to everybody else. I'm Derek Relaford, and this is the Elkhart Tapes. Stay engaged, stay safe, and stay curious. We'll see you next time.